Welcome, everyone. It's my pleasure to introduce to you a colleague of mine from the Administrative Office of Pennsylvania Courts, our Judicial Security Administrator, Mr. Rob Granzow. Rob came to AOPC about 4 or 5 years ago from academia, but most of his career has consisted of working in law enforcement and the military. And because of his really wide and disparate background, he brings a unique perspective to safety and security, uh, addressing the personal needs of safety security as well as our own roles as core professionals. Rob is keenly aware of the ethical questions that have been posed, will be posed to all of us, and have been posed in the past as well. But before we dive into that ethical dilemma confronting our court administrators regarding access, let's first take a look at addressing one of the essential needs we have, which is our own safety and the expectations we have of our government to provide a safe environment for doing business with and within our own government. So with that, one and all, I introduce to you Mr. Rob Granzow, who will be taking a lead on our presentation.
I appreciate your kind comments, and thank you to the group for the opportunity to join you today for this very interesting topic, a topic near and dear to my heart. I think it's safe to say that safety and security within the judicial system, within all judicial systems, within our courts, it's an imperative, it's a concern that's near and dear to our hearts. And it's near and dear to our hearts for a number of reasons, but certainly we have to acknowledge the fact that there is that assurance that there is an equal access to justice under the Constitution. And beyond that, though, I think it's incumbent upon us, it's required for us as court administrators to assure and ensure that the fair and equitable administration of justice is best realized in an environment of safety and security. We cannot bring forward the work that we do if we are entering into an atmosphere of fear. And that would be true of the court users and the litigants and all employees serving before the bench. So safety and security is paramount, not only as a constitutional consideration, but certainly as a requisite for that fair and equitable administration of justice. So that being said, I think, and in giving thought to today's comments, I found it interesting that the challenge before us as judicial professionals at the end of the day is one that legal scholars and legal ethicists and human rights advocates, as well as security architects such as myself, ponder. And we ponder it on a frequent basis, and that is quite simply, how do we ensure security for those with disabilities as well as for those without disabilities when entering into our judicial system? I think it's incumbent upon us to fully appreciate all the nuances of that question. I don't think we can come to a mature resolution or bring forward solutions until we really embrace the depth and the breadth of the issue at hand. What we're talking about here is security, and safety is derived from security. But security must accommodate our court users, our staff, our jurists, the communities we serve. It has to accommodate those individuals who have physical disabilities. And when we talk about physical disabilities, I think it's, and just reflecting on some of my notes here, those who have traumatic injuries, those who suffer from congenital birth disabilities, as well as those who have come before us having psychological and life traumatic events. I think when we talk about ensuring safe and secure access to justice, not just equal and equitable, I think it's important that we appreciate those who have cognitive disabilities, whether it be intellectual, neurodiversity, or even age-related. The other area that we have to consider, quite frankly, is the populations who are suffering from some type of mental illness or a personality disorder, or as I said earlier, those having traumatic injuries to their mental well-being from life events or military service, as our country has been engaged in for approximately the last 20 years. I think we need to be appreciative of those having addictive disorders. And ultimately, I think we need to be sensitive to those having cultural and language disabilities. They are not able to appreciate, to navigate, to understand the nuances of a culture that might be dissimilar to theirs, and certainly language barriers. So there's a lot of nuances here when we talk about ensuring a safe and secure environment for those who might be marginalized by disabilities, because disabilities is a broad topic, and we need to provide unique and innovative solutions to meet their needs. So that being said, I think as a group, we should agree that what is our best next step forward for your court, for our court? And I think it certainly begins with articulating a very mature security plan. What should security look like? What are we trying to achieve without respect to any particular group of individuals? What level of security? Are we trying to create a fortress, a castle, if you will, or is this a public building where the administration of justice occurs for one and for all? Excuse me. So with that being said, it's important and it's critical, it's essential that we gather the stakeholders. Everybody has a voice at the table, and we try to identify where is that sweet spot of security and what is the concern for one and for all. And once you get that, then I think you're well positioned to determine and to launch into the analysis of, and one of the approaches that I still favor is the gap analysis. So what is our current state? We know what we want it to be, but where are we? And that's a hard nut to crack sometimes, because it involves recognizing, realizing, appreciating, and acknowledging that we might be far removed from where we could be or should be. And that's in part because we are living in a rapidly changing threat landscape. The challenges facing today's courts are unique. They weren't necessarily evident 50 years ago, and they certainly weren't evident in the frequency or the prevalence that they are today. So there are other nuances, but the threats and the risks facing an urban judicial system is similar yet very dissimilar to the threats facing a very rural, remote environment. And so we need to take a very careful and methodical look at what is our state of security, what is our current state. And that begins with a security assessment, a comprehensive security assessment. We recommend starting with a self-assessment and then going in with competent, certified professionals who can actually bring forward the observations that many times we don't see because we're living and working in those environments. I think once we get an understanding of where are we today, and we have that security plan of maybe the way it should be in the end, we need to articulate the desired state. What security features, processes, procedures, and people and resources are required to go from where we are to where we want to be? And our desired state is closely aligned, if not completely aligned, with that original statement concerning a security plan. The desired state might entail significant changes to how we do what we do and the resources that are needed to accomplish those ends. But you have to articulate the desired state before you can enter into the third prong of the trident, and that is the gap closure. We know where we are. We know where we want to be. We have an overarching security plan of how we can bring a safe and secure environment to all parties coming before the courts. Now, how do we get there? And quite frankly, with the gap closure, I think we need to look at a number of things. All too often, I find people wanting to throw money at a situation with the hope that it brings resolution, improvement. And money certainly is required. I understand that. I understand that better than anybody. But I think the prudent use of money and the innovative use of ingenuity and leveraging technology and making data-informed decisions, data-based decisioning is critical. We cannot work off of our impressions. We need to have the evidence in front of us. How many people with disabilities are being served by the courts, and what are the breakdowns of those, so that we can direct the resources where they are most needed. Otherwise, we're just kind of throwing money at a problem, and it might work, and more times than not, it doesn't. I think also that if we're going to do this, we need to look at, when we're doing the gap analysis more specifically, what resources? Well, money's one of them. How much money is it going to need to accomplish these ends? Well, before you can answer the money questions, a lot of times you have to ask the overarching question: what do we need in terms of capital investments and with technology? And so we bring that to the table. What capital investments are required? And what resources do we need once those capital investments, the funding is ensured? Interestingly enough, another often overlooked and probably the most important is, do we have the political buy-in from the executives, the political entities, to accomplish this significant culture shift in many instances? If we don't have the commitment and the buy-in from the top, a lot of our efforts are going to be waylaid or fall to the wayside and never come to fruition. So that's absolutely critical. And I think, the other aspect we need is, not everything costs a lot of money. And I'm an advocate of technology. Believe me, I am. And we're going to talk about that. But a lot of what we're talking about here today is not what we do, but how we do it. And so if you're dealing with somebody who has post-traumatic stress disorder from time in the military, a dear friend of mine is a wounded warrior in many capacities. He has a master's degree, and he's a great human being, but he absolutely decompensates in a thunderstorm. So what do we do when we're dealing with people with these types of issues, and how can we best protect them and protect those around them from situations? Another situation I'm familiar with, a gentleman was a tortured prisoner. Can you only imagine what the sight of handcuffs, even dangling on the belt of a deputy sheriff, might be? It could very possibly precipitate an event. So there's a lot of considerations, not in only what we do, but how we do it. And I think it's important that we need to be sensitive to those, especially with neurodiversity, noises, crowds. Maybe it means having earphones, earmuffs to lessen the noise when they come into a loud, busy judicial center. I think, we have to have realistic timelines set forth. That change doesn't happen overnight, and the procurement of resources doesn't happen overnight, but the training is critical. How many courts have the benefit of having a large staff that's widely trained in psychological first aid? The best part of psychological first aid is not in what you do with somebody in crisis. The best part of psychological first aid is being able to see somebody going into crisis. Okay. And so while the course is normally brought forward that when somebody's in crisis, this is what you do, I have found, and I'm on the board with the American Foundation for Suicide Prevention, and I work with families who suffered a recent loss, and it's a passion of mine. And I realized that some of the greatest benefits of that particular training, psychological first aid, has to do with seeing somebody start to devolve the decompensation process and being able to intervene properly so that it doesn't get out of hand. We do a lot of de-escalation training, and de-escalation training is great. It's very important. I think it's imperative. But I really feel non-escalation training is more appropriate. And that's one of the things that I'm pushing. Law enforcement's all about de-escalation. Get called to a chaotic situation, and this is how you maintain control. And you don't let somebody cross those boundaries, and you de-escalate somebody on the edge. How about let's not escalate it at all? Let's not push that envelope to the point where it's able to fall off the edge. And that goes back to being able to recognize people in crisis so that you can have alternate strategies and procedures in place. I understand that individuals possibly confined to a wheelchair might not be able to go through a traditional magnetometer. Nonetheless, I'm very familiar with a situation where an individual came into a courthouse with a handgun under their lap blanket with an extended magazine and 26 rounds of ammunition. They were not coming to court, ladies and gentlemen, with that kind of armament for self-protection. Okay, something bad was really going to happen, and by the grace of God, the deputy sheriffs were able to insist that the individual surrender the lap blanket. They were using hand wands very discreetly. They were sounding, and they were able to seize the weapon, and nobody was hurt. What's the point? We have to have innovative methods and methodologies and processes and procedures for dealing with a segment of our population who might be somewhat dissimilar to us. Otherwise, we run the risk of exacerbating that situation, or worse yet, not fostering an environment for the fair and equitable administration of justice to occur. So it's good that we broaden our understanding of the issues at hand. It's good that we look at some of the solutions in terms of process for improving court security and better ways to protect the America's third branch of government. But I will close with, it's good to talk about things, but it's really good when you have solutions. And I think when we talk about situations such as this, it's incumbent upon us to come forward with solutions. I think the time is right to have a conversation, to start a dialogue on what opportunities may exist for an expanded utilization of video conferencing or for remote proceedings where permissible by your respective court systems. I think while police dogs, canines, I have a 110-pound German Shepherd who thinks she's human. While I think police dogs and canine assets are invaluable, okay? A patrol dog that's a bite dog, it has its purpose. Bomb dogs have an even greater purpose in a courthouse. But are you aware that there's something called a gun dog? And a gun dog sniffs the common solvents used to clean firearms, and it can even detect the plastics used in certain firearms, such as Glocks and SIGs and Walthers and some of the others that the firearm, the frame is comprised of plastic polymers. If a dog alerts to that, that's an option if you can't put somebody through a magnetometer, for instance. I think we need to talk about an expanded use of not just the Garrett wands and wanding, but innovative ways to do the wanding. To tell somebody, like they do at the airport, put your arms out, put your arms up, stand up, sit down. I mean, how about discrete wanding methods where you're talking to somebody and another deputy were to step into the scene and say, my partner's simply going to hold this wand and it's part of our screening process, if you don't mind. And instead of being so offensive and aggressive with it, to actually use the device discreetly in a non-threatening manner. I think there's some opportunities for us to explore expanded use of AI surveillance technologies. We have technologies now that will detect a bump on the hip or a bump on the ankle, and it will cue the people that the person coming in, okay, is probably armed. All right. And even technologies that will look for behaviors of anxiety, okay, that this person's not acting the way they necessarily could or should. Will detect a person in a winter coat coming in the courthouse in the summer, okay, and it flags those individuals, allowing for special attention, okay. So we have to leverage technology to its fullest. And certainly there's another technology, when we're speaking of that, I'm not endorsing any particular brand, but you'll see them at most stadiums and large venue events. It looks like vertical advertising in a large version of what you might encounter in a retail setting. And it has advertisements on the sides. But when you walk through it, it's a video-based analysis, and it chirps, and it will tell one person, the person operating the instrument, this person here on video needs to be physically screened. So you can literally push 15 people walking through this in a mass, and it will single out those that truly necessitate further screening. We could use that type of innovation, that type of new technology as a preliminary screening measure or a primary screening measures for those who are not capable of the traditional magnetometer approach. So just a number of thoughts, but just to summarize, I think it's really incumbent upon us to appreciate the diversity of the challenges that fall under the term disability. And I think we need to make reasonable accommodations to serve these people, to ensure their fair and equitable access to justice, okay? Whether it be from a language disability, an intellectual disability, a physical disability, an emotional, mental illness, or even a substance abuse. If somebody starts into withdrawal, okay, what are we going to do? How are we going to handle this? What if they are reacting because they need something and they missed their methadone? Are they going to be able to stay with the process in court, or are they going to further devolve? Lots of issues, and our security measures have to accommodate these issues, because if they don't, the issues aren't going to go away, and the only thing that will result is a lesser administration of justice, or worse yet, an inequitable administration of justice. So my thoughts for you, and I certainly welcome any questions you might have on my perspectives.
Thank you, Rob. I wanted to start off our discussions, and I know you've touched on a lot of these areas that if we think about that, that does resolve that ethical dilemma that we might be facing. But the first question when I thought of this, when Courtney and I we were talking about this program a month ago, is this really an ethical question? Doesn't everyone want a strong physical security presence? And then I recalled, well, not everyone. And so I'll ask all of you, do you agree with that? Or do you think that there are individuals out there that that really do want a less of a presence of security, and that it's too intimidating and it's too much of a police environment coming into instead of a neutral public house?
Rick, I think that's a great question. It's something that I speak on a lot here in Missouri, and I think it's I think the majority of people that come into our courthouses and courtrooms enjoy a level of security and safety. I think it becomes a different issue when you are in traffic court and you see up the judge, there is an individual in the same uniform as the person that issued you the ticket. I think that sends a completely different message. So I think those are things to be cognizant of. And, you know, there's a lot of things, you know, that come into play. And I think in today's litigious society, the first thing that popped into my mind as an administrator is, what's going to happen if we misidentify someone as having some type of problem, especially in some of those situations where there may be a PTSD moral type of injury, or, you know, those unseen issues that we just don't know about. You know, people don't typically come to court because they're excited to be here, right? So there's a level of anxiety that is assumed when they walk into a court setting. That typically this system is not set up for the general public to understand and be able to maneuver in. So especially if they're coming in unrepresented, or have preconceived notions of the court, they're already coming in anxious. So a lot of those things we can't see, and those are certainly the challenges. You know, the expansion of treatment courts and specialty courts, and, you know, that brings a whole nother group of people into our courthouses. So the education piece that Rob talked about, I think, is just so imperative. The education and being able to identify, and once you do that, then what happens? And I think that there are issues to talk about there at some point, that everyone's entitled to be in the courthouse, right? But at the same time, we have to draw that line to where it is a safe space for everyone. But that is really difficult. And you know, I think all of the things, I'm like, oh, let's go out and get some psychological first aid, and also some gun dogs. And then it's like, well, who's gonna pay for that? Like,
Absolutely.
great. So I mean, there's little you know, idiosyncrasies that are built into everything, but recognizing that there's problems also would potentially leave us open for, oh, so you knew there was a problem when this happened. And, you know, to publicly acknowledge that there's a problem without having that second and third piece of possible solutions, and then filling those gaps, is really difficult. Difficult to manage. So Rob, I think it was a great presentation, and Rick, I think that was a great question.
Well, and I think the question maybe as we get close to the top of the hour here, but I'm curious to hear what all of you think. And I'm kind of intrigued to see if we have diametrically opposed viewpoints, because I think they could both be right. What do you think your obligation or your responsibility is regarding safety and security and access for our courts?
Rick, may I jump in just with one quick comment here, building on what Courtney said? You are so spot on with your remarks. I look at what other industries are doing. Certainly the hospitals are plagued with violence, all types of challenges. They've taken some approaches. Airports are another. But one approach that I haven't been able to find traction yet, but I see immeasurable value, and that is in having courthouse ambassadors, where you have people who are trained, let them wear just a blazer, open collared shirt, or a polo with an emblem. And when people come in, they are an upscale door greeter from a major box store. Good afternoon, good morning, how are you today? May I help you find something? Or are you looking, you know, however they may. Phoenix Airport does this. They have a legion of retirees in blazers. And when they see a traveler with a perplexed expression, they come right over to them and, hi there, you look like you might need some help. How can I direct you? It is a godsend. I look for these people anymore when I travel, because they totally de-escalate my stress and my anxiety. And I really think that there could be an opportunity within the judicial system, within courthouses, to further explore having ambassadors who would be there in a customer service capacity to identify people who look lost, confused, or under stress, unique stress, and simply extend a heartfelt good morning, good
Rob, would
afternoon.
you put them inside or outside security?
I would put them immediately inside.
Okay, because one thing I have noticed is, we're located on street level.
Sure.
And you can hear from our office, take off your watches, your belts, and the screaming that takes place. And it's like, nothing says welcome. Like,
Absolutely. And that goes back to the methods and not only what we do, but how we do it. But I think there's great opportunity here. And
yeah,
I thank you all for, again, affording me to share my thoughts.
Roger, you had a question or comment.
I have a comment. So I work for the Multnomah Circuit Court in Portland, Oregon, and we have come up with some solutions for this, following these guidelines. We have identified this issue of people coming into the courthouse and having to go through security and having that airport-style security and the armed officers at the door. But we do have help on the inside of security. So we have a self-help center, but we also have a greeter, as you were suggesting, Rob, at the beginning. We only have someone down there in the morning hours when it's the busiest, but we do have a full-time staff member who is a customer service analyst, and that person is available all day to assist customers who are having a difficult time. And they're highly trained in how to listen and how to seek out any accommodations that these people may have. And they also work with our staff and our supervisors to train them on how to best deal with these individuals. And it's been really a great opportunity. And I think the lesson here for court administrators and managers is we need to learn how to train our employees and ourselves how to listen. We need to listen first. We need to be able to identify accommodations. We need to learn to pause and know what to say and who to contact if someone does need a certain accommodation. And we also need to have regular meetings with our security personnel. So, I think that there are times when people who come through that security or who have an interaction with an officer or an unpleasant experience in a courtroom, they need someone to be able to talk to, and we need places for those people to turn. And then we need to follow through, and we need to go back and have those open conversations and those courageous conversations with the sheriff's office or the police department, whoever they may have had that interaction with. In our court, unlike some of the courts in this country, we don't have armed officers or guards. We don't have bailiffs. We don't have people with guns in the courtrooms. There are certain custody cases, of course, where there's a dangerous person who is going to be in the courtroom. So we do have sheriffs in the courtrooms at that time. But I've discussed this with, with other managers and other courts, and they're shocked. They're like, "What do you mean you don't have a sheriff with a gun in your courtroom? On all felony cases?" I'm like, well, we don't have the money, first of all. Our sheriff's office doesn't have the funding to be able to have those officers in all of the courtrooms. And also, just as we were talking about, the optics, and how does that make, the other participants in the courtroom feel? Does it raise the level of anxiety in the courtroom when you have already opposing sides sitting in the courtroom? Does having a gun present, aggravate that? So those are my thoughts, and I just wanted to share what we do here.
Well, and to piggyback off of that, because I am in Multnomah County as well, because as Roger said, we don't have deputies always in the courtroom. I'm actually in charge of all of the judicial clerks. So the judicial clerks are stenographer clerks and bailiffs. They are technically our bailiffs in the courtroom. So I train the clerks to ensure security in our courtrooms a lot of the time. So it's usually like the ground level person knowing it. And it is all about perception and optics and just being aware and observant in the courtroom too. Like for instance, even just yesterday, I was waiting for the elevators. I was saying hi to some of my clerks, and somebody who was definitely has some mental health cognizant inabilities or something along those lines, was definitely wandering around asking people for money. Most people were just ignoring him or turning him away. Well, he ended up getting in my elevator. I saw that he was going to the 15th floor, which is where I know the mental health coordinator is. So it was very clear that he was going to that floor where he was going to go to a mental health treatment court. Knowing that, I was a little less abrasive than the person next to me. So when he turned to the person next to me in the elevator and said, "Hi, how are you doing?" She completely ignored him, immediately got off the elevator. Granted, that was probably good for her. That's what she needed to deal with. But when he turned to me and said, "Hi, I'm so-and-so," I'm like, "Hi, I'm Erica. How are you doing today?" You know, and he's like, "You're very nice. Would you like to go on a date?" I'm like, "Sorry, sir, I'm actually engaged. So that's probably not the best idea." And he's like, "Oh, so then us getting married is probably not going to work out." I'm like, "No, sorry, sir, probably not." And then I got off the elevator and I'm like, "Have a good day, you know, say hi to Judge Waller for me." And he's like, "Thank you, I love you." And that was it. And afterwards, one of my clerks reached out and she's like, "Oh my gosh, did you have to call the deputies?" And I'm like, "No, absolutely not." And I explained how I handled the situation. And I'm like, "See how you would never have had to call the deputies for somebody like that?" Because even when I said no, he was like, "Oh, okay." You know, it wasn't anything abrasive or rude. He was honestly just shooting his shot, you know, but it was very clear that he was not here for anything else but the mental health court. But in interacting with him, it actually led to something better than what could have been if somebody had just either continued to ignore him or worse, called the deputies. So it's teaching my clerks lessons like that of how to respond appropriately and how to take note of what the situation is. And more often than not, I mean, we have the ability to Teams message our deputies in the courtroom. So more often my clerks are messaging the deputies rather than hitting that panic button and just saying, "Hey, I might have a situation. Could you maybe be on standby?" And more, I swear, 99% of the time, the deputies are like, "Looks like everything worked out okay. Doesn't look like you need us." So it's that immediate reach out for help if you need it, but try to de-escalate it as much as you can from the get-go. So, and never approach something as, "Oh, this is the end of the world."
I'd like to chime in, and I agree with a lot of what all of my colleagues are saying. Taking it back to the call of the question, sort of this balancing between there being this police presence or this presence of heavy security versus keeping the courthouses safe. One of the things that Rob mentioned was that security assessment and that self-assessment. And I think that's going to be extremely important because you want to take that data-driven approach. If you're having issues in the courthouse and there are data is showing that there's a lot of incidents, you may want to decide to sort of ramp up that security. But you may have a situation where the data is indicating that you're not having that much trouble. No matter what the scenario is, another thing that Rob spoke about was making sure that the approach that the security is taken is something that is welcoming, right? The way that you approach people. So you can still have the same security measures without approaching people in a way that's abrasive or making them feel unwelcome. Because when I think about courts, when something does happen, that looks very bad. It looks very bad upon the leadership. So we want to make sure that we are preventing things from happening, even if it does cause some discomfort. Another thing that my colleague Roger touched on was sort of the relationship between security and our folks that are working within the courthouses. That also makes it easy for our officers and our security when we have that connection with them. So that way we're working with each other. And it's not a matter of, okay, let's just call security to handle everything. Maybe there's a situation where you're in a courthouse and you start to notice signs of someone acting up a little bit, but it doesn't rise to the level of needing security to step in. Can you text message that officer just to take a walk in and a walk out and let that officer know that that's all you want them to do? That may diffuse the situation before it gets out of control because this person sees, oh, wait a minute, there's some security here, but it's not enough to the point that would make anyone feel unwelcome. And when we think about welcoming, we also have to ensure that our court users coming in, that they feel safe and protected as well. So there's going to be some people that know that, hey, we're coming into a courthouse. There could be some contentiousness with the fact that there are lawsuits going on, whether it's civil or criminal, and we want to feel safe when we come there. So it's a balancing act, and that use of technology, Rob, that you spoke about, how you can have some security measures that are more discreet. So with the technology, we may not even realize how heavy the security is. So I think that may be the win-win in that scenario where you can still have heavy security, but it doesn't seem like it's as heavy as it actually is because we're utilizing the best of the technology. And that's all I'll say on that. I appreciate this discussion.
Does anybody have any final words? Well, thank you all for joining us today, and we look forward to hopefully seeing you all in New Orleans. And if we don't see you there, then we will see you on August 22nd when we celebrate my birthday. Excellent.
Thanks for joining us today. The Question of Ethics Conversation is a regular segment on ethics, courts, and court administration. Today's episode will be available on our website, in the Court Manager Journal, on the Court Leader website, on YouTube, Facebook, iTunes, LinkedIn, and on X, formerly known as Twitter. Become part of the conversation. Join us live when we hold the Question of Ethics Conversation. Episodes are held immediately following the monthly NACM Ethics Subcommittee meeting on the fourth Thursday of the month. Check the NACM Committee webpage for the schedule and Zoom link. If you have questions, comments, or ideas for future conversations, email us. Our address is ethics@nacmnet.org. Did you hear an interesting comment by one of the panelists that you would like to listen to again, but you don't want to search the entire episode to find it? The Additional Resources section on the webpage has a question time marker sheet. Find the discussion question on the sheet, and next to it is the time that question was asked. You can quickly fast forward to that time and listen to the panelists' comments. Remember, if you don't have time to watch an episode, you can always listen to the audio version. Listen in your car or on the bus on your way to or from work. You never have to miss an episode. I'm Pete Kiefer, and on behalf of our guests, the Court Leader website, and the National Association for Court Management, thank you, and have a great day. The views, information, and opinions expressed during this episode are solely those of the hosts and the individual presenters. They do not necessarily represent the position of the National Association for Court Management.